Paul. I'm just looking in this law dictionary. Yes. They have what's called due care, the type of care that a sensible person exercises in a situation requiring carefulness. A good example would be when a person, prior to taking a long automobile trip, has his car checked out thoroughly before embarking upon the trip. Yes. Now, the type of care a sensible person exercises in a situation requiring carefulness. Now, a lot of courts, they would say, well, you really don't have to be careful when you're issuing protection orders because it doesn't matter what it actually does. The concern is for the petitioner and the minors named, and it doesn't matter how they're issued as long as they're issued that way. You can arrest the respondent even though you didn't do what the law requires. Now, you would think, okay, that it might be used in other court systems. In fact, I was reading this. Defense counsel requests that the state prove the defendant received actual notice of the petitioner's request for permanent order and that the Pelham County courts had sufficient basis to justify the imposition of the permanent order as noted above. These are not required elements of the charged crime. The state does not need to prove them. As concluded in the State versus Miller 156 Washington 2D 27, the validity of the underlying no contact order is not an element of the crime of violating such an order. Now, let's say you're a prosecuting attorney in another county and your county decided to issue a protection order where the petitioner didn't sign it. The respondent didn't get actual notice and opportunity to be heard. This happened approximately, 16 times. And it's not in Clallam County. Let's say it's in King County or Pierce County or any of the counties in any state of the United States. And instead of actually just removing it because it violates federal legislation and it violates the 5th and 14th Amendments of the Constitution and it violates Article 3 of the Washington State Constitution and it violates the due process clauses in every state constitution, you decide you're not going to enforce the law. And then all of a sudden another guy that has a protection order issued against him that wasn't given actual notice and opportunity to be heard before it was issued. It turns out that prosecuting attorney decided that, as concluded in State versus Budnick 156. See, you take the Miller out and you put a Budnick in there. Now, somehow I think as furthermore City of Auburn versus Solis Marcal, it's going to be City of Squim versus Paul Budnick. Okay, my name's going to end up in a lot of arguments from a lot of prosecuting attorneys. Now, I don't know exactly how this Washington App 398 works. But when Mr. Budnick was personally served the order for protection August 15th of 2015 in a public library so that all of the patrons could witness it. And it was issued having numerous forgeries on it. And those in the judiciary said, well, he's got a remedy. He should just motion the court. I'm kind of thinking that I could be the reasoning for the prosecuting of innumerable numbers of those that get arrested for violating protection orders that they had no knowledge of. Now, as much as you wouldn't think there would be damage in the quadrillions for not removing the protection order once you had knowledge that it violated the constitutional right of due process, I'm kind of thinking after hundreds of thousands of emails, and can see how many times my email addresses have been hacked, that as soon as my name shows up in any reasoning for prosecution, because BUDNEK shows up in every court argument everywhere in the nation, I'm telling you right now,